Joining me now, criminal defense attorney and former prosecutor Robert Bianchi. So, Bob, you and I talked about this case just earlier this week. The judge really set up today because he brought up 2 prior suicide attempts by Conrad Roy, and each time he stopped himself and he called his parents or he called a friend.
Right.
And then he points out that this time he stopped himself and he called the young woman who was supposed to be his girlfriend.
Right.
And she didn't talk him back down.
She talked him back in. And this is what we had talked about previously about this case. I mean, she had been coaxing him for 2 solid weeks, talking about how he needs to be with God and that his family will understand. And then she actually started,
they'll get over it.
They'll get over it, taunting him a little bit, like, are you gonna do this? Are you gonna lie to me again? But the problem in this case that people are not getting, in my mind, is that when he's in that vehicle and doing it, and she's on the phone soothing him into continuing to stay in the car, and he says, I can't take it, and gets out, and she says, get back into that car. Remember, she had told him how to do it, and alternative plans should it not work. These are very aggressive actions. And Erica, we talked about this the other day. The Supreme Court in the state of Massachusetts had already reviewed this case, which I think was another defense failure in this case, and they had said, if the government, the prosecution, proves those facts that we just discussed, then that could constitute involuntary manslaughter. So what the judge had right in front of him was a template set out for him by the Supreme Court, and all the judge had to do is say, are the facts that are alleged true, beyond a reasonable doubt or not? And the defense never argued that they weren't true. It's crazy.
Were you surprised at all that he specifically brought up this doctor? Natisha mentioned it, but he said, I also want to let you know, I don't find this doctor's analysis that perhaps in the medication you were on, Michelle Carter, was somehow impairing your judgment. I don't find him credible.
Well, you know, that's what you see. This is why you don't waive a jury in cases, because a singular man made a credibility decision on a singular witness. But that said, I agree with the judge. It is not a legal defense for intoxication unless it prostrated your faculties to the point where you really don't know the difference between right or wrong. But look at her. What prosecutors do is they talk about the conduct immediately before the person was on the medication and right after. And what did she do right after? Not only was she thinking clearly, talking him into killing himself, she then went into the mode of texting her friends, calling his mother, where's your son, and then playing the victim. So the judge, that's nowhere near intoxication. Why they would have put that on with a judge who knows the law, I don't know. With a jury, that may have had some sizzle. Different.
Yeah, it's just that, you know, it is a terrible story all around. Again, sentencing now for the beginning of August. Bob, good to see you. Thank you.
Thank you.